So real estate, like any other asset, when we divide it in a divorce, it's a three-step process. So we first have to classify that asset. We have to figure out if it's marital. So if a couple bought a house during the marriage, that's going to be considered a marital asset, subject, to certain things like where the money came from. So there are times that we need to see, did they pay for it on their own? Was that money that one of the spouses had prior to the marriage? Was it money that was gifted to one of them or gifted to both of them by a parent or another relative? But once we have determined if it's marital, we value it, and then we're either dividing it, meaning that we're taking the value and one person is getting their share of that value, the other person is keeping the house. Other times we're selling the house if that's what makes the most sense. And then there were also times that the house is not getting sold or the value distributed at this time, but the custodial parent is remaining in that house with the children until they're of a certain age, typically when they graduate high school, at which point the house then gets sold and the proceeds distributed. And so that's with respect to the marital residence. When they have second residences, other homes, vacation properties, investment properties, the distribution is handled, a little differently. We don't have that continued occupancy issue typically. So in New York State, the way we divide assets is under the system known as equitable distribution. Equitable from the word equity, meaning fair. We fairly distribute the assets. And to do that, that's a three-step process. So the first step is to classify the asset. And in a New York divorce, there's two classifications of assets. There's separate property, which doesn't get valued and divided, and marital property, which does. So first we need to determine whether the asset is separate or marital. Once we know which one it is, if it's marital, we then have to value it. And then that's step two. And then in the final step, we have to distribute that value. We have to equitably distribute that value. In New York, with respect to the vast majority of the assets, in the vast majority of marriages, courts are distributing things 50-50. They're distributing them equally. It is different with businesses. We're seeing the non-titled spouse getting typically less than 50% of their share, though there has been a trend where the percent that the non-titled spouse gets has been moving up. When we have properties beyond just the marital residence, when we have a vacation home, which, for instance, which comes up quite a bit, the vacation home will be valued and the value shared between the two parties. One may keep it, one may buy the other person out. The parties may or may not be able to afford to keep that second house, in which case it can make a lot of sense to sell it as part of the divorce proceeding. There are times when people have, significantly more real estate than that, investment properties, whether they're multifamily, individual homes, commercial real estate. Those things get valued, and typically there's a buyout. Sometimes people do have to liquidate, if the bulk of their net worth is tied up in real estate, then we will see things being liquidated. There are times we've had cases where both parties leave with ownership of real estate. If both are fairly sophisticated, are comfortable, running the real estate on their own, or perhaps they've been, that's a business that we'll often see both parties, both husband and wife, will have been involved in. In those circumstances, maybe, we'll value and we'll divide them up, that way. And then they can keep running the business and receiving the income and the tax benefits that come with owning that type of real estate. A prenup can be really critical when people have significant real estate holdings, particularly when they're coming into the marriage with that, whether it's something that they inherited, that they will inherit, that they already own a portion of, because those assets can have obviously significant value, number one, and number two, if we have addressed them in a prenup prior to the marriage, it makes the divorce a lot simpler and a lot less costly. So that's something that when that exists, we will most certainly provide for it in a prenuptial agreement if we have that opportunity. We discuss real estate in a divorce. It may be as relatively straightforward for us as divorce lawyers, obviously not for the parties themselves, but if they just have a marital residence, there's several options available to us. Obviously, the more significant real estate holdings that parties have, the more sophisticated the resolution may need to be, and that's really where having experts representing you, One of the things I love about having a firm and the value of having multiple attorneys with decades of experience is that we've seen quite a bit, and we've been able to do a lot of creative things to help people get out of their marriages financially in the best way possible.